before the court is Theodore versus Ronald Stobbs. The state has waived, so you will have your full 15 minutes to argue, should you wish to use it. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. Don't use the names of any minors or children, although I don't believe that's an issue at all in this case. We have read your briefs and we are ready to begin when you are.
Thank you, Your Honors. Good morning, may it please the court. My name is Attorney Connie Hightower, and I represent the defendant who is also the appellant in this case. This case is fairly simple. This deals with the sentencing, of which the defendant pled no contest to his original charges in the trial court, with the knowledge and the intent to address whether or not he was going to receive jail time credit for the restricted halfway house program. So essentially, briefly with the facts, he had spent a period of time in the restricted halfway house program. One of the things that I noted in the brief was that continually during the case, they referred to what we call RHH in the brief for restricted halfway house as the RIP program. And there's various programming at Oriana, as I know that Your Honors are very much aware, and some of those have full restrictive and some do not have full restrictive. In this particular case, during the pendency of the case, although the defendant was in the restricted halfway house program, it was referred to as the RIP program. Consequently, when he first...
Are they one and the same or not?
Well, RIP has various programs, and so I think that, Oriana has various programs, so I think that RIP is a part of a halfway house program, but it's not necessarily the restricted halfway. So if I'm saying it correctly, I believe there's various components that require the level of supervision you have, and some may allow you in and out privileges, and some may not. And with the restricted halfway house program, those privileges, you're on full restriction. So
RIP is work release.
Well, yes, sometimes, but I know sometimes, Your Honors, that they do also send people to RIP for drug treatment. And that there's some other programming that is housed in the same house as the RIP program, but not necessarily called RIP. Of course, casually, everything is referred to as the RIP program. With this particular case, on January 14th, he pled guilty to the single count, which was count one, vehicle under the influence of alcohol and a drug of abuse, pursuant to the Rule 11 plea negotiations. At that time, his counsel did bring up that there were discussions with the state as to him receiving credit, and the judge made it clear that she was not going to grant credit because she believed it wasn't restrictive. Again, when they had another hearing on February 11th, where there was a sentencing, it again arose and the same discussion occurred, and the trial court judge indicated that she wasn't going to grant credit, gave him 22 days jail time credit, but not credit that he would have had in the restricted halfway house program.
Whose responsibility is to determine that issue? Is it the court's initial obligation, or is there an obligation on the part of the defense counsel to bring in manuals, etc., from restricted halfway house to give the court that basis to make that finding?
Well, Your Honor, that goes directly to the second assignment of error, where the second assignment of error was that there should have been a hearing held. So in that, I believe that when a defense files a motion, such as in this case, and a motion for reconsideration, which was filed in State versus Napier, which was a 9th District case, when the defense files that formal motion, so there was a formal motion and there was a motion for reconsideration filed, then I think it's imperative for the court to hold a hearing under State v. Napier. So the burden would be on the defendant to provide that information to the court, but the court should allow a hearing for the inquiry on the level of restriction.
Why was that sentencing hearing not the hearing to address that issue? Especially in light of counsel's statement that he or she would argue further at the sentencing.
Your Honor, I believe, if I recall, and let me double check in my recitation of the facts, I believe that there was a summary denial of the original motion and the motion to reconsider. I believe that the formal paper motions that were filed were denied by the court prior to there actually being a hearing on the issue, hence the motion for reconsideration. So if under RC and to the first assignment of error, which is essentially a credit for time served, under 2967.191, a prisoner that is confined for any reason arising out of offense for which the prisoner was convicted and sentencing, including confinement in lieu of bail while awaiting trial, those days shall reduce that person's prison term. So I believe, Your Honors, that what occurred in this case is maybe the loose use of the word RIP had maybe perhaps the trial court judge or the prosecutor having an idea as to what type of program he was involved in, but not really realizing that it was the restricted halfway house program. As in Napier and a couple of the cases that we cited in our brief, once the court made an inquiry and they find out that the restriction is a full restricted halfway house with no privileges in and out, much like a community-based correctional facility, then at that point in time, then that defendant should be entitled to that jail time credit. In this case, the defendant had requested 112 days of jail time credit. The court gave him 22. We're estimating that that leaves him somewhere in the mid-90s in jail time credit that he should have received for the halfway house program, the restricted halfway house program. So our request under assignment of error 1 is for this court to reverse and remand for the appropriate jail time credit to be provided to the defendant. Under assignment of error 2, if this court is not comfortable with that, would be to reverse and remand so that a hearing would be held to determine the level of restrictions for the particular program that this defendant was participating in, so that the court can make a decision as to whether or not to issue the jail time credit under that program.
Of course, CDCF, you can't leave the facility and come back.
Correct.
Of course, you're charged with escape if you
Correct.
don't return.
Correct, and we didn't argue that per se in the brief. CBCF, would say is more aligned with the restricted halfway house restrictions. But again, that would be something that would be more fleshed out, as you mentioned, Your Honor, with maybe a brochure to the judge or a formal hearing to determine the level of restrictions. But it is the restricted halfway house, so you have no privileges under that program, even though it's referred to as a halfway house.
So if you leave the restricted halfway house, don't come back, you're going to get charged with escape.
Correct, you're subject to all the penalties that the court could impose for leaving that particular program. And if Your Honors have no, oh, sorry. Okay. Thank you. If Your Honors have no further questions, then that will conclude our argument.
Thank you very much.
Thank you.
All right, thank you for your presentation. We'll take the matter under advisement and we will issue a written opinion, which will be mailed to both sides and as well as posted to our website.